Good morning, good afternoon, good evening to everyone, wherever you are in the world. Welcome to this episode of the Privacy Espresso. Today we have Juan Carlos Manriquez Rosales, a leading expert from Chile, but I would say throughout the Latin American continent. Juan Carlos is the partner and founder of Manriquez and Bonavides Lawyers in Chile, and also professor at the University for what concerns economic crime, and has an expertise related to cybercrime and international crimes committed through the internet. Today we are discussing about privacy versus surveillance and artificial intelligence in criminal proceedings in order to learn where are the limits. I also take the chance to inform you that Juan Carlos will be speaking to public institutions at the highest level in Chile on the 13th of April this month, specifically about this point. And I'm also pleased to say that Juan Carlos is one of the co-chairs of the PrivacyRules, Cybercrime and Privacy as a Fundamental Right Committee. So Juan Carlos, welcome today again. We have a very short time frame, so let's start immediately with the conversation with you. We talk about artificial intelligence. So when we talk about algorithm predictability, can they create a transformation of the criminal justice system, in your opinion?
Hi, everyone. Yes, this is a very relevant question because I think the artificial intelligence, the algorithm justice, if we can call in this form, really are in this moment operating, I think, in very huge levels and degrees inside the criminal justice systems in different parts of the world. The possibility of to use the algorithm to predict, rule the judicial situation of the different convicted or suspected people under the criminal justice. In my country, an example, in this moment, is possible because the defense public attorney has developed a system of predictable solutions to different types and forms of the potential charged people. When the public defender have to confront the evidence, the fiscal prosecution requirements with the evidence, and he needs to go in front of the court, in this moment, he has a tool in his hands. And he can occur and apply the technical tools and obtain 3 or 4 potential answer for his case. And I think in other way, our justice in our Supreme Court or in other parts of the world, and in Chile specifically, the criminal judges are really surprising and amazing for the possibility to use these new tools. But I think this is a long distance, because for this final situation, you need 2 or 3 new steps, because machine learning to obtain new knowledge, but they're operating without feelings. And the common sense or another open objective criteria that normally used inside the criminal justice are not present in this scenario. But the environment really is changing.
Thank you very much, Juan Carlos. We completely agree with you. And we also know that you recently published an article related to the possible gender discrimination of the artificial intelligence. Talking about this topic specifically, what's your opinion with regards to the European Union moratorium against the facial recognition and other biometrics? It's something, in your opinion, has risen as a meaning should be adopted by other criminal justice systems?
Yeah, I think the moratoria adopted by the European Union is a prudential decision, because the scientists and the lecturers and criminal lawyers, writers, or searchers agree that currently the artificial intelligence in facial face recognition is very dangerous, because we don't know precisely where is the origin of this load of information, photographies, faces, and the possibility to enter in levels of discrimination, gender discrimination, racial discrimination, and labeling approach for built and criminal solutions or public policies to combat the crime are very dangerous, the use of biometrics in this moment has many very good angles, and we have to be happy with this. But give the possibility to track, to trace all of your decision and movement, and buy without control, without judiciary control before your private life and your private space when you have legitimate expectations of privacy. The coronavirus crisis in this moment permit to develop different tools to trace, in example, people in its movements and flights to avoid the expansion of the crisis. But you have not the control of your face, of your fingerprint, of your voice included, or your iris in your eyes, where all this information is collecting in this moment, and why is the final purpose to use. And when the police departments and the policymakers and the lawmakers inside our parliaments are trying with this information without, repeat, judiciary control, you have the possibility to cause a very huge damage in the human rights protection system, because you have to make a balance, surveillance, security, privacy, human rights, and due process. An example, the Federal Constitutional Court in Germany in May 19 ruled the illegal situation when the journalist was traced by the surveillance agencies and others for intelligence purposes. Because this situation without judiciary order, it's violating, conforming this rule, the privacy, human rights, free speech, and other fundamental rights. Similar like that is the situation with the Patriot Act inside the United States, but with another goals, applying also in Latin America and different parts of the world. And in Chile, in this moment, we had a very curious case in our hands, because as you know, the fiscal prosecution used during several months a drone to obtain evidence from, or filming evidence related with a group of drugs trafficking people inside a private place. But this drone was flight without aeronautical authorization and judicial authorization. In this case, the criminal court of Santa Cruz, a little town 500 kilometers from Santiago, southbound, ruled this was illicit proof and illicit evidence because it was obtained without judiciary order. And the space over this site is also a private site. You need a judicial order, similar like in the United States by the 4th and 6th Amendment.
Right. Thank you very much, Juan Carlos, for mentioning this. It's a very important precedence, if you want, of international relevance, because as you rightly noticed, this is happening in other countries as well. And this is one of the most debated topics. As you perfectly know, also thanks to you, the privacy rules we like very much speaking with law enforcement, with judges, international organizations, in order to discuss together about these controversies and the balance of powers, and also the pros and cons of having limitations on the one side and respect of privacy as a fundamental right on the other side. Unfortunately, this is a fascinating topic, but time is running. Thank you very much everyone who was with us today for this Privacy Espresso virtual in Chile. Juan Carlos, thank you very much for being with us. Thank you, and hopefully we will meet again in another important event we have in Latin America on the 1st of June. Follow Privacy Rules, register to our newsletter and social media, and you will discover more. Thank you, everyone. Thank you.
Thank you for calling. Bye.